Bill Henshaw here again, Constitutional Crisis Channel, and I want to talk to you in this video about bond redemption, another program I've recently become aware of. And just as I said, with the status correction, I have some real problems with this in a constitutional sense. Not that I think anyone's out there to try to make an easy buck or is acting in bad faith, but I think it's a misunderstanding of the laws that we should be using in order to get around these bastards. Because it's bond redemption looks like to me, and I'll get back to you when I confirm it, but it must be intimately related to the bankruptcy of the United States in 1933, declared by Congress 2 or 3 days after that bastard FDR got into office. And they said henceforth that it's against the public policy of the United States to pay debts. The net effect of that was to make us all hypothecators of goods or stipulators in the admiralty. And that's a term you can find in an earlier case they decided called Bank of Columbia v. Oakley, Okley, 4 Wheaton 217, I believe is the citation on that. And they talk about the fact that this guy in 1819 took out a loan with the bank and somehow wasn't able to pay it back in time, and the bank wanted to foreclose on his property. And he said, wait a minute, I've got a right to a trial by jury here. He wins in the district court. He wins in the Court of Appeals. The Bank of Columbia goes to the U.S. Supreme Court. And like a famous football commentator in September, they say, not so fast. When you made your note negotiable at the bank, you entered into a stipulation and became that hypothecator of goods or stipulator in the admiralty. By the way, that citation on Oakley is 4 Wheaton 235. That's the page number. So the point with that is it really helps us, because if we're stipulating in the admiralty jurisdiction, guess what? Article 3, Section 2 of the Constitution prohibits state courts from exercising admiralty jurisdiction. They can't do it. Hell, admiralty was the central cause of the American Revolution, for crying out loud, a jurisdiction foreign to our Constitution and unacknowledged by our laws. So where the hell are you when you go into a traffic court, for example? You're not in a state common law court of general jurisdiction. Not there, despite the fact that California was admitted into this union as a common law state, as were all other states except for Louisiana, who, as a result of the Louisiana Purchase, they were practicing near the Napoleonic civil law, and they maintained that particular course of law, although they would have had problems had it come into conflict with the common law. I don't know of any cases where that happened, but they're the only state that's not admitted as a common law state. So this stuff gets really interesting here. Now, those that go in there about bond redemption are not only have to overcome hurdles like this, but they then also have to look at, how did we get this way? What bond is it that we're trying to redeem? And this apparently goes to the birth certificate. And there's a long string of events that happened here. I don't have all the pieces to this puzzle, but apparently when you get a state-issued birth certificate, and I don't have one as far as I know, mine came from a private Adventist hospital. Even better yet, I have my family Bible. That's relevant admissible evidence. If you don't, apparently these quote-unquote state birth certificates somehow find their way to the Department of Commerce, and somehow, there's bonds issued against us for which we're liable. This process isn't entirely clear to me. Those of you that want to learn more about it, try listening to some videos of Gene Keating, Jeankeating. He's not as easy to follow as I would like, but he knows a great deal about this, and I'm still trying to figure out what exactly happens here. But that said, they can do that and take our birth certificates and, in effect, take away our status, standing, and citizenship without us having any part in challenging it. What the hell does that say in a government that was set up to be a federated republican government of defined and limited powers based on the rule of law and the consent of the governed? Where can we find our voluntary, knowing, and intelligent consent to having our status, our rights, and our states destroyed? And this, by the way, voluntary, knowing, and intelligent, That's the reference standard of the Supreme Court for finding a valid such waiver. Case is Johnson v. Zerbst, Zerbst, 304 U.S. 458. Now, these are the kind of issues I'd much rather be arguing than this other nonsense of this type that assumes they have the power to do this. And this, by the way, may be a power delegated to a quote-unquote unitary president. You know, that's a catchword for those New York bastards up there on Wall Street. Unitary banker and unitary president that has all this unlimited power, and yet Congress doesn't have any authority to delegate it, or they would not have such power if we were in a state. The fact that we're in a territory is a whole different situation, but the problem with that is that they have to prove that Congress has power to relegate states admitted into this union to a lesser political status. If you can find that in your copy of the Constitution, I'd love to see it. I can't, they can't, and this is why they back down when we challenge the badgers, because they know they have nowhere to go with issues like this one. This is what gets charges dismissed, because if this issue goes to the 904s in Washington, D.C., we win. I mean, either that, or they're going to have to openly declare martial law rule and a military government. And I'll have a little bit more to say about that on one of the next videos coming up here, trust me. But this stuff with bond redemption, I don't buy it, and I don't think you should either. I'll report more when I know more. Thank you.